Thank you, Mr. Speaker. It's my pleasure to rise this afternoon to speak to second reading of Bill 2, the Protection Against Family Violence Amendment Act. I want to thank the Honourable Minister of Children and Youth Services and her department for their initiative in bringing forth this important piece of legislation and for allowing me the privilege of sponsoring the bill in the House. Family violence has devastating consequences, Mr. Speaker, for many people in our province. One of our government's top priorities is to prevent and address family violence so that all Albertans feel safe in their homes and communities. This bill will enhance the safety of individuals and families affected by family violence through protection orders to protect those who have experienced family violence and to prevent further violence. Each year, Mr. Speaker, 1,700 applications for emergency protection orders are made in the province of Alberta, and 80% of those are granted. The proposed amendments reflect the advice received from key stakeholders on needed changes, and those stakeholders included the law enforcement communities and Crown prosecutors. The most significant changes brought about by these amendments would be to ensure that there is more consistent enforcement of protection orders and that breaches are met with sanctions, which will send a strong message to perpetrators that breaches will not be tolerated. Currently, Mr. Speaker, the Act does not provide any specific provisions for prosecuting breaches of protection orders. Presently, the situation is that police and prosecutors have the option of either prosecuting a breach of a protection order either as ordinary civil contempt of court or as a violation of a general provision, Section 127 of the Criminal Code of Canada, which is a general provision that creates an offence for breaching a court order. Since both of these provisions are applicable to a whole range of breaches of court orders, some of which are minor, some of which are very serious, and everything in between, the penalties that are meted out under each of those particular avenues of prosecution vary quite considerably. And so this has led to some inconsistency in the penalties which are applied for breaches of protection orders. The amendment which is proposed in this bill will clearly spell out in the Act that breaching a protection order is an offence and it will carry specific penalties. Mr. Speaker, I believe that these measures will help to ensure consistent enforcement across the province. And the Department will continue to work closely with law enforcement and the legal community in the event that these amendments are passed, and they will be asked to provide input on any required changes. The penalties proposed in these amendments, Mr. Speaker, were determined in discussions with Justice and Attorney General and a review of other domestic violence legislation across the country. The bill proposes fines up to $5,000 and possible jail time of up to 30 days, or both, for a first offence. Mandatory jail time ranging from a minimum of 14 days and up to 18 months for a second offence, and a minimum of 30 days incarceration and up to 24 months for a third and subsequent offences. Mr. Speaker, if passed, this legislation will send a very strong message that a breach of a protection order is a serious matter which will bear very significant consequences. The remaining three amendments are housekeeping issues that will help clarify the processes and streamline administration of the Act by the courts. The first will repeal a section that specifies the type of justice of the peace who has the authority to grant emergency protection orders. This will leave the assignment of a justice of peace up to the discretion of the justice system, which will align the Protection Against Family Violence Act with changes to the Justices of the Peace Act. Amendments to the Protection Against Family Violence Act will also clarify how evidence is presented and considered when emergency protection orders granted by the provincial court are later confirmed and possibly extended by the Court of Queen's Bench. Amendments will also clearly define the type of communication considered contact under a protection order. Protection orders may include provisions forbidding a perpetrator from contacting the abused person. The change will clarify that contact includes both direct and indirect communication. Including indirect communication will make it clear that a perpetrator cannot harass someone indirectly, for example, using a third party to contact an individual under protection order. Mr. Speaker, the measures in these amendments will not be a cure-all for family violence. Other measures such as women's shelters, safe visitation sites, early intervention and counselling, and addiction treatments are all being improved by the Minister and her department, and all with a view to breaking the cycle of family violence. However, these proposed amendments will improve our response to this issue, and it will provide some additional measure of increased protection for people affected by family violence. And I am therefore very pleased to move second reading of the Bill 2, the Protection Against Family Violence Act. And at this time, Mr. Speaker, I would move adjournment of further debate on the bill.